A company assigns its trademark without the business. They keep the factory, but sell only the brand. 6 months later, the assignee tries to record the transfer. The registrar refuses. The refusal happens because an assignment without goodwill has zero legal effect until the assignee obtains directions from the registrar and advertises the assignment. This chart outlines Section 42. It governs the mandatory advertisement requirement. This is a condition precedent. The IPAB ruled in the Nico Quality Products case that Section 42 is absolute. It cannot be waived, bypassed, or cured retrospectively. No advertisement means no assignment. Welcome to Patentworld-ai, Lecture T4 for the Trademarks Agent Exam 2027. Today, we cover how trademarks change hands. We will examine assignment, transmission, the twin restrictions of Sections 40 and 41, the Section 42 trap, and the registered user system. Substantive trademark rights depend entirely on strict, sequential procedural compliance. Let's look at the rules. Looking at this breakdown of the Act, Section 37 establishes that only the registered proprietor, the person currently on the register, has the legal power to assign the mark and give effectual receipts. Moving down to Section 38, a registered trademark is assignable and transmissible with or without the goodwill of the business. Subsection 2 permits partial assignment by goods class. You can assign the mark for Class 5 pharmaceuticals to one company, but keep Class 30 foods for yourself. The assignee simply gets a separate registration. Section 39 extends this exact freedom to unregistered marks. They are also assignable with or without goodwill. Assignment is a transfer by active parties, executed through a voluntary contract. Transmission, by contrast, occurs by operation of law. This happens automatically during events like death, succession, or corporate merger, without a voluntary handshake. The 1999 Act decoupled the trademark from the physical business. The brand is now a standalone, tradable intellectual property asset. The registry allows free transfer of marks, but it actively blocks any assignment that creates public confusion. This table compares the two primary restrictions. Section 40 prohibits assignments that result in different persons holding exclusive rights to identical marks for the same goods. An assignment violating this rule is void, but there is an escape clause. The registrar may consent to the assignment if satisfied no confusion will arise. Do not confuse Section 40 with the partial assignments we saw under Section 38, subsection 2. Partial assignment by different goods classes is valid. Section 40 specifically targets identical marks ending up with different owners for the exact same goods. Section 41 governs geographic restrictions. It prohibits assignments that create exclusive rights for the same mark and goods in different parts of India. Section 41 is an absolute prohibition. Unlike Section 40, there is no registrar consent exception available. India does not permit U.S.-style territorial brand splitting. Modern consumers travel frequently, and regional ownership of the same brand creates nationwide confusion. Returning to our opening scenario, assigning a mark without goodwill triggers the Section 42 process outlined in this table. In Step 1 and 2, the assignee must apply to the registrar for directions on exactly how to advertise the assignment. In Steps 3 and 4, the assignee must publish that advertisement in the exact form directed, and they must do it within 6 months of receiving those directions. For special marks, look at Section 43 on this page. Certification marks require the registrar's consent prior to assignment. Public trust in the certification must survive the transfer. Section 44 dictates that associated trademarks can only be assigned as a whole. You cannot split them.
To assign just one associated mark, you must first formally dissolve the association under Section 16. Then you can assign it separately. Finally, under Section 45, the assignee must register their title. This graphic details the timeline for filing Form TM-P. The process requires a 9,000 rupee fee for e-filing. The application must be filed within 6 months of acquiring title, which is extendable by a further 6 months. Until this title is officially recorded, the assignment cannot be admitted in evidence by any court to prove title, except by direction of the court. Acquiring a mark through a private deed is legally incomplete. The transfer must survive the registry's statutory requirements and be formally recorded on Form TM-P. Moving from ownership to licensing. This table compares the statutory advantages of a registered user, the registry's official licensee, against a standard contractual user. Under Section 48, subsection 2, Use by the registered user is explicitly deemed to be used by the proprietor. This deemed use provides critical protection. It defends the mark against Section 47 cancellation for non-use, even if the actual proprietor never personally uses the brand. A second major statutory right is found in Section 52. The registered user can institute infringement proceedings in their own name. There is a procedural prerequisite. The registered user must first formally call upon the proprietor to sue. They can only take independent legal action after a mandatory 2-month waiting period. Registration requires a joint application by both the proprietor and the user on Form TMU, accompanied by a 4,500 rupee e-filing fee. Compare this with the permitted user under Section 2, subsection 1, Clause R. They operate by mere written consent and are not entered on the register. Section 53 expressly bars a permitted user from independently suing for infringement. Relying on a private, unregistered contract leaves a licensee powerless in court and leaves the proprietor highly vulnerable to non-use cancellation. Registered user status is not permanent. Section 50, detailed here alongside Rule 80, states that the registration can be varied or cancelled by the parties, or by the registrar suo motu. Under Section 51, the registrar can demand confirmation of the user agreement at any time. Furthermore, under Section 54, the registered user has no right to assign their permitted status to anyone else. Section 55 establishes that use of one associated mark counts as use of the other registered marks within that group. This tight regulatory oversight prevents naked licensing. It ensures the proprietor maintains quality control, so the trademark retains its distinctiveness in the market. Let's run the trap simulator. Question 1. Can a registered mark be assigned without goodwill? Yes, Section 38. Assignment creating identical marks with different owners for the same goods? Void under Section 40, unless the registrar consents. Territorial split of ownership within India? Absolutely void under Section 41. No consent is possible. Assignment without goodwill takes effect when? Only after the registrar's directions and advertisement under Section 42. Certification mark assignment needs the registrar's consent. Associated marks assign how? Only as a whole. Time to record an assignment on Form TM-P? 6 months, extendable by 6. Whose use defeats a non-use attack? The registered user's. It is deemed the proprietor's use. Can a permitted user sue for infringement? Never. Barred by Section 53. Mastering these strict dichotomies is essential for the 2027 agent examination. That is T4. Next, in T5, we tackle cleaning the register, Section 47 non-use removal, and Section 57 rectification. Subscribe and see you there.